Hello guys, my name is Gauri Bandre. I'm an intern at LEXIS and Company, and my topic for today's discussion is guardianship under Hindu law. In today's discussion, I'm going to talk about what is guardian, who is guardian, what are the types of guardian, and few of the questions which are related to guardianship under Hindu law. So, to begin with, let us first understand who is guardian, uh, what are the laws which cover guardianship under Hindu law, and what are the different types of guardian, what powers are allotted to the guardians, etc. So, there are two specific laws which deal with guardianship. First is Guardianship and Wards Act of 1890, which was made by East India Company to deal with the welfare and to protect the rights of minor. This act was secular in nature, so it was not only related to Hindus, but it covers all the religion. Second is that of Hindu Minority and Guardianship Act of 1956. So in this act, there are all specifics which are mentioned. This is only related to Hindu law and doesn't cover any other religion in it. Uh, so now let us see what is the meaning of guardian as per Hindu Minority and Guardianship Act of 1956. So guardian means a person having the care of the person of another or of his property or both. So any person, there are types of guardian obviously, but any person can be appointed as a guardian who will look after the welfare of the minor child. Okay, so guardianship is basically divided broadly into four types. One is natural guardian, second is testamentary guardian, third is appointed or declared by the court, fourth is a person empowered to act as such by or under any enactment relating to any court of wards. Start by understanding each and every guardianship briefly. First is that of natural guardian. So natural guardian is somebody who is not appointed by the law, but who looks after the child as of his own. Okay, so natural guardian consists of parents. Priority, they are parents or anybody who is bloodly related to the child, or in good faith is looking after the child. Understand the cases in which we can see when the natural guardianship is given to whom. I have divided the situations into four types. One is in case of legitimate child, second is illegitimate child, third is adopted child, and fourth is unmarried girl child. So first is legitimate child. In case of legitimate child, the priority is always given to the father. In absence of the father, it is given to the mother. But if the child is below the age of 5 years, then the custody and the guardianship is most probably given to the mother. Second is in case of illegitimate child. In case of illegitimate child, the priority is given to the mother, and in absence of the mother, it is given to the father. Third is of adopted child. In case of adopted child, again, first is father and then the mother. In case of married girl child, the priority is of his husband, that is the guardianship is under the girl's husband. If the husband is minor, then it is given to the girl's parents. What does after him or absence of means? In case when the main guardian is the father, if he is not present close to the child, or he is not able to provide the child whatever he needs, or maybe he is not agreeing with the uh, welfare of the child, or is not able to take major decisions, or is unfit mentally or physically, then in that case the major guardianship can be shifted to the mother. If the mother is unfit or unwell, then it can be transferred to the father, vice versa. It mostly depends on the welfare of the child. So it is, the whole concept is not concentrated on who has the right to have the guardianship over whom, but is about the welfare of the child, where the child is most suited to be with. Natural guardianship can be disqualified on the basis of two reasons. One is if the person, the main guardian, ceased to be a Hindu. Second, in case if he or she has renounced the world. Okay, the question comes, what happens if the parents are divorced? Then what happens to the minor child? Is custody and guardianship same? No, then the custody and guardianship both the concepts are very different from each other. Custody is quite narrow in concept and doesn't give you much right to have a control over a minor's property or of his own benefit. Whereas in guardianship, the guardian has right to take major decisions of the minor. Also in custody can be limited for a specific period, but guardianship is permanent in nature. Now let us see what are the powers given to the natural guardian. First is to do all the necessary and reasonable and power for the benefit of the minor and the minor's property. So the guardian has the power to take all the major decisions of minor's life and minor's property. Second is the guardian cannot bind the minor in any major contract. Third is can lease minor's property for maximum of 5 years, and in case where the minor has attained majority can maximize it till 1 year. It means if, for an example, the minor is of 16 years and he's completing his majority by 18 years, then after completing his majority he can maximum keep it for like 1 year, matlab until he complete his age of 19 years. Until then he has time to withdraw the lease. Fourth is the guardian cannot transfer, mortgage, or charge, sale, gift, exchange any immovable property in name of the minor without prior permission of the court. If it is in the benefit of the minor, then the guardian has the right to do it, but with the prior permission of the court. Last is if anything, now if the guardian does anything which is out of the prescribed boundaries by the law, then the contract will be void ab initio, that is void from the beginning, and it won't be binding to the minor. Next guardianship is testamentary guardian. Now what is testamentary guardian? Testamentary guardian is any guardian who is appointed by the natural guardian. Now the testamentary guardian can only act as a guardian in absence of the natural guardian. If the natural guardian, that is the parents, mother or the father, is present, then the testamentary guardian has no right to over the minor's property or his life. Okay, now if the father is present, then the father will be given the whole right. In the absence of father, it will be passed to the mother and not any external third party guardian which will be appointed by the father. If the mother is dead, then it will be passed to anybody who is appointed by the mother. If she hasn't appointed anyone, then it will be passed to anybody who is appointed by the father. If both have not appointed anyone, then the court has the right to take the decision in the benefit of the minor child. Now, what are the powers of the testamentary guardian? Then it is as same as that of the natural guardian. Third is anybody who is appointed by the law. So anybody who is appointed by the law, that is de facto guardian, doesn't have a right over the minor's property and can't take any decision to deal or to dispose of minor's property. Now let us see a few questions which we come across while dealing with guardianship. First is, can a minor be guardian of another minor? Then yes, our Hindu law deals with guardianship and restricts the minor to deal with minor's property, but doesn't say anything regarding a guardianship of minor to a minor. Now in this case, yes, a minor can be a guardian of a minor person, but not his or her property. Now the next question is, does a guardian have a power to take decision in case of JFP, that is joint family property? Then the answer is no. Any external guardian doesn't have any right to take decisions regarding to JFP, because joint family property is covered under Mitaksha law and the whole right is given to the Karta. So in absence of any natural guardian, the Karta will take the provided decisions, because in joint family property, the right is not only of one particular person, but it is equally divided to all. So the Karta is the main who act on behalf of the minor. And in case if the Karta is absent and the major management is over the minor, then in that case, a external guardian can be appointed by the court. And if all the co-parcenaries are minors, then also the court can appoint the guardian. Next is, who is next friend? Now we always come across this term next friend in CPC. Next friend is somebody who is temporarily appointed by the court to guide the minor in legal proceedings. Okay, so he or she doesn't have guardianship over the minor for a long period, but only through the specific period or the allotment of the legal proceedings. So these were a few of the questions which were related to guardianship and the concept of guardianship. I hope that you liked this video. Do subscribe to this channel. Thank you.